Hello everyone. Our group was tasked to discuss the continuation of the Republic Act number 8799, the Securities Regulation Code, Chapter 6 and 7, amended version of Section 68, Title 1 to 3. The main objective of the SRC is the protection of the investing public. Well, of course, it includes the shareholders of the corporation itself. I will discuss the first half of that chapter, section 19 and 20. One way to protect the shareholders' interests is the tender offer rule. But first, what is a tender offer? A tender offer is a publicly announced intention of a person to acquire equity securities of a public company. These tender offers are regulated to prevent the stockholders of the target company from being misled by the offerer or the target's management. Therefore, a principal requirement of the law is the disclosure by the offerer of certain information about the offer and a copy of that information being given or sent to the stockholders. Section 19 of the SRC and its implementing rules give us the situations where the person or group of persons would be required to make a tender offer for equity shares of a public company. First paragraph says that they should also file a declaration to that effect with the SEC. If they intend to acquire 15% of equity securities in a public company in one or more transactions within a period of 12 months, a tender offer is made by filing with the SEC of a declaration to make a tender offer. Second paragraph, all other requests or invitations for tender offer or materials making a tender offer shall be made in accordance with the rules and regulations prescribed by the SEC. In short, any person making a tender offer should make an announcement of its intention to do so. Third paragraph, the offerer in a tender offer shall permit the security standard to be withdrawn. Fourth paragraph, if the tender offer is less than the total outstanding securities but a greater number of securities is tendered instead, then the offerer shall be obliged to accept and pay the securities on a pro rata basis. Last paragraph, in a scenario where the offerer is in a tender offer increases the consideration offered after the tender offer has commenced, he shall pay such increased consideration to all security holders whose tendered securities have been accepted for payment by such offerer. Subsection 19.2, the law also says that it shall be unlawful where a tender offer has commenced or is about to commence for. Section 20, proxy solicitations. 20.1. The bylaws of the corporations shall be controlling in determining the proper procedure to be followed in the execution and acceptance of proxies, provided that the minimum formalities of the revised corporation code and the securities regulation code are complied with. 20.2. The law says that the proxies must be in writing, signed by the stockholder or his duly authorized representative, and filed before the scheduled meeting before the corporate secretary. 20.3. Unless otherwise provided for in the proxy, it shall be valid only for the meeting for which it is intended, and no proxy shall be valid and effective for a period longer than 5 years. The S.R.C also says that a broker or dealer cannot give a proxy in respect of any security that it carries for the account of a customer without the express written authorization of such customer. In other words, if it wants to give a proxy, get the authority written of the customer first. The law says that every person who is directly or indirectly the beneficial owner of 10% or more of any class of any security of the corporations should file a statement indicating the amount of securities of which he is the beneficial owner. He should file the statement with the SEC and with the exchange. If the security is listed on an exchange within 10 calendar days after the effective date of the registration statement for that security.
Solicitation, let's discuss the fees of tender offers and certain proxy solicitation. Section 21, fees of tender offers and certain proxy solicitation. So, according to this section, whenever a statement needed by Section 19 for a tender offer, Section 72 for issuer purchases, or Section 20 for a solicitation of proxies or consent is filed with the Commission. So, the Commission may impose a fee on the party submitting the document of no more than 1% of the following. First, the anticipated total acquisition price if a transaction falls under Section 20 or 72.2. Second, in the event of an acquisition, merger, or consolidation, the cash and value of any securities intended to be received upon the sale or other disposition of such assets, or the cash and value of any securities proposed to be received in the event of a solicitation under Section 20. Diminishing fees that are inversely correlated to the offering's total price must be prescribed by the Commission by regulation. Now, let's move on to the Section 22. Internal record keeping and accounting control. 22.1, the law says that the following corporations must adhere to Section 22 under the SRC. First, the issuer who has sold a class of registered securities. Second, a company whose securities are listed for trading on an exchange. And third, an issuer with at least 50 million in assets or any other amount that the SEC may specify, and 200 or more holders, each of whom holds at least 100 shares of a certain class of the issuer's securities. So therefore, these corporations are required to abide by Section 22 and must carry out the following obligation. First, they must create and maintain books, records, and accounts that fairly and accurately reflect the issuer's assets, transactions, and disposal. Second, they must also design and maintain a system of internal accounting controls that is effective in ensuring that transactions and access to assets are authorized by management, and the financial statements are prepared in accordance with generally accepted accounting principles. And last, at intervals that are reasonable, recorded assets and existing assets are compared and the discrepancies are resolved. So now, we're going to discuss the last section for this chapter, Section 23, the transactions of directors, officers, and principal stockholders. 23.1, under this section provides that any director or officer of the company that issued the security, as well as anybody who is directly or indirectly the beneficial owner of 10% or more of any class of that security, must carry out the required acts. Next, 23.2 states that unless the security was bought in good faith in connection with a debt already contracted, any profit made by the beneficial owner of a security of an issuer in a period of less than 6 months will significantly contribute to and be recoverable by the issuer. 23.3 declares that any such beneficial owner, director, or officer is not permitted to sell any equity securities, whether directly or indirectly. No individual shall be deemed to have violated this subsection if the person in possession of the security fails to deliver it in exchange for the sale within 20 days of. And last one, 23.4, any purchase and sale of this security shall not be subject to the provisions of subsection 23.2. Such securities may be defined, prescribed, and regulated by the Commission through any rules and regulations it deems appropriate or necessary in benefit of the public.
Now that we're done discussing Chapter 6, we're going to discuss the following chapter, Chapter 7, which is about prohibitions in fraud, manipulation, and insider trading. In the following sections, exchange means an organized marketplace or facility that brings together buyers and sellers and executes trade of securities and or commodities. Section 24, which is the first section under Chapter 7, is about manipulation of security prices, devices, and practices. Section 24.1 provides for the acts that are considered unlawful as they artificially induce the price of a security by using manipulative practices. It states that it shall be unlawful for any person acting for himself or through a dealer or broker, directly or indirectly, to create a false or misleading appearance of active trading in any security traded in an exchange by first effecting any transaction which involves no change in beneficial ownership, second, by entering an order for the purchase or sale of a security knowing that another order for the sale or purchase of such security has been or will be placed at a substantially similar size, time, and price. Or third, by performing similar acts where there is no change in beneficial ownership. So the first subsection in Section 24.1 provides that when there's just a mere transfer of security and no change of ownership, misleading and false appearance of active trading is created. This will create a false appearance on the mind of the investors and will be tempted to invest as well because of the apparent trading. The second subsection under Section 24.1 states that it shall be unlawful for any person to affect alone or with others securities or transactions in securities that first raises the price to induce the purchase of a security, second, depresses their price to induce the sale of a security, or third, creates active trading to induce a purchase or sale of a security by using manipulative devices such as marking the close, painting the tape, squeezing the float, hype and dump, boiler room operations, and such other similar devices. So first, marking the close is the deliberate buying and selling of securities at the close of the market with the intention of securing a closing price at a favorable position. Second, painting the tape means engaging in transactions of securities that would create an impression of activity to induce investors to invest in such security. Squeezing the float is controlling the demand side and taking advantage of market congestion and shortages of securities to create artificial prices. Hype and dump is engaging in the dissemination of false information to spark a buying frenzy which would increase the price and then after dispose the shares at an inflated price. And then lastly, boiler room operations are operations designed to promote the purchase and sale of securities by the use of high-pressure sales tactics. So to reiterate, the mentioned practices are prohibited as they involve techniques that would manipulate investors, inducing them to purchase securities. The third subsection under Section 24.1 provides that it shall be unlawful for any person to circulate information that the price of any security in an exchange will or is likely to rise or fall because of manipulative market operations conducted by one or more persons for the purpose of inducing the sale of securities. Section 24.1.d provides that it shall be unlawful to make false or misleading statement with respect to any material fact which he knew or believed to be false for the purpose of inducing the purchase or sale of any security in an exchange. Section 24.1.e provides that it shall be unlawful to effect transactions for the purchase and or sale of any security traded in an exchange for the purpose of pegging, fixing, or stabilizing the price of such security unless of course otherwise allowed by this code or by the Commission. Pegging is the purchasing or selling of large quantities of a security to affect its price, driving the price in a direction that is favorable for others. So now let's move on to Section 24.2, which provides for the prohibitions of the use of any manipulative or deceptive device in connection with the purchase or sale of any security. So short sale and stop loss is also prohibited unless they are done in accordance with the rules and regulations of the Commission. Short sale is the selling of stocks that a trader does not own. The trader borrows a stock for a specified time and sells it once the price is higher or when the time period expires. Stop loss orders are designed to limit an investor's loss on a security position. So these are orders placed to a broker to buy or sell a specific stock once it reaches a certain price. Section 24.3 states that despite the previously mentioned provisions, the Commission, having due regard to the public interest and protections of investors, may, by rules and regulations, allow certain acts or transactions that may otherwise be prohibited under this section. So Section 24 prohibits the use of devices and practices that would manipulate the prices of securities. The acts mentioned are prohibited since they intend to manipulate the security prices to the prejudice of the investing public. Because again, the main objective of the Securities Regulation Code is the protection of the investing public. If the manipulation can be proven to have taken place, the sale shall be voidable at the option of the buyer, without prejudice to any liability for violation of the SRC against the person who caused the manipulation. Now that we're done with Section 24, let's now move on to Section 25. Securities and Regulation Code also provides for regulation of option trading under Section 25. Options is a contractual agreement between two parties regarding a particular asset. They give the holder the right but not the obligation to either buy or sell the asset at a predetermined price on or before the contract expires. Its most basic types are calls and puts. Call option, simply defined, is the option to buy the underlying security at the strike price on or before expiration. It becomes more valuable as the underlying security price rises. Put option, on the other hand, is just the opposite of call, but gives the holder the option to sell the underlying stock at the strike price on or before expiration. It becomes more valuable as the underlying security price declines. So straddle is a neutral option strategy which involves buying a call and put option simultaneously. Option trading is speculative in nature and can carry a substantial risk of loss. Under Section 25, any member of an exchange is prohibited from directly or indirectly endorsing or guaranteeing the performance of any put, call, straddle, option, or privilege in relation to any security registered on a securities exchange. The terms put, call, straddle, option, or privilege shall not include any registered warrant, right, or convertible security.
So let's move on to the next section, Section 26, Fraudulent Transactions. It is prohibited for anybody to act in the following ways in connection with the purchase or sale of securities, whether directly or indirectly. First, utilize any method, plan, or trick to defraud. Second, obtain money or property by making false assertions about important facts or omitting to mention important facts that would have rendered those statements, given the context in which they were made, not misleading. Or three, engage in any behavior that constitutes or would constitute fraud or deceit against any person. Section 27, Insider's duty to disclose when trading. First, it is prohibited for an insider to sell or purchase a security of the issuer while in possession of substantial information about the issuer or the security that is not generally known to the public unless a. The insider establishes that the information was not obtained through such relationship, or b. If the other party selling to or acquiring from the insider or his representative is identified, the insider proves either he revealed the information to the other party or he had cause to think that the other party also has access to the information in some other way. A transaction involving the purchase or sale of a security of the issuer by an insider as defined in Section 3.8 or by that insider's spouse or relatives by affinity or consanguinity within the second degree, legitimate or common law, shall be deemed to have been made while in possession of material non-public information if it was made after the information had come into existence, but before it was made public and a reasonable amount of time had passed for the market to stabilize. Provided, however, the purchaser or seller must demonstrate that he was aware of the relevant non-public facts at the time of the acquisition or sale in order to refute this presumption. Second, for the purposes of this section, information is deemed to be material non-public if it meets one of the following criteria. A. It has not been generally leaked to the public and would likely influence the price of the security after being made public and after a reasonable amount of time has passed for the market to absorb the information, or B, a reasonable person would deem the information to be important in the circumstances when deciding whether to buy, sell, or hold the security. Third, it shall be prohibited for any insider to disclose substantial non-public information regarding the issuer of or the security to any person who, as a result of the disclosure, acquires insider status as that term is defined in subsection 3.8. If the insider disclosing the information knows or has a reasonable grounds to suspect that the recipient would likely purchase or dispose of the issuer's securities in full while in receipt of the information. Fourth, letter B, the phrase securities of the issuer sought or to be sought by such tender offer must include any securities convertible into or exchangeable for such securities, as well as any options or rights in any of the aforementioned securities for the purposes of this subsection. Fourth, letter A, it is prohibited whenever a tender offer has started or is going to start for number 1. Anyone other than the tender proposer who is in possession of important non-public data pertaining to such tender offer to either purchase or sell the securities of the issuer that are sought or to be sought by such tender offer if such individual understands or has a reason to believe that the information is non-public and has been obtained directly or indirectly from the tender offerer, those acting on its behalf, or the issuer of the securities sought or to be sought by such tender offer. And second, each and every tender offeror, those acting on its behalf, the issuer of the securities sought or anticipated to be sought by such tender offer, and any insider of this issuer to communicate material non-public information pertaining to the tender offer to any other person in which such communication is likely to result in a contravention of subsection 27.4, letter A, number 1.
We will now be discussing the SRC, or the Securities Regulations Code, Rule 68 as amended. Title 1. In this provision, we would only talk about the application of the rules and the definition of the terms stated in this rule. Let's start on the application of the rule. This rule applies to the corporation that I will be mentioning. The form and content of the financial statements must be properly followed and filed with the Commission by these corporations. Number 1. Stock corporations with paid-up capital stock of 50,000 or more. Non-stock corporations with total assets of 500,000 or more, or with gross annual receipts of 100,000 or more. 3. Branch offices of stock foreign corporation and non-stock corporation with assigned capital or revenues amounting to 1 million or more. Lastly, regional operating headquarters of foreign corporations with total revenues amounting to 1 million or more. Financial statements of branch offices of foreign corporations licensed to do business here in our country shall comply with the requirements of this rule unless otherwise determined by the Commission. We can now move forward in the definition of terms used under this rule. Financial reporting framework means a set of accounting principles or standards that must be followed in the preparation and submission of the financial statements. Entity refers to a juridical person or a corporation registered under the Corporation Code. Error means an unintentional mistake in the financial statements which may affect the accounts of the entity. Fraud is an intentional act by one or more individuals that results in a misrepresentation of financial statements. Gross negligence means wanton or reckless disregard of the duty of due care in complying with Philippine standards on auditing. Material information, coming from the word material, means information whose omission or misstatement could influence the economic decision of its users. Significant subsidiary. This is kind of technical, so listen carefully. Shall we say we have a parent and then we also have the subsidiary of a parent. And now we're going to have the subsidiary of the subsidiary. It will become significant if it exceeds the 10% of the total assets or income of the corporation and its subsidiaries consolidated or joined as of the end of the reporting period. Title 2. General Guidelines to Financial Statements Preparation. Under Financial Reporting Framework, the financial statements that shall be prepared and filed by the entities covered by this rule shall be in accordance with the Financial Reporting Framework as prescribed under this section. We have three kinds of entity, namely, large or publicly accountable entities, small and medium-sized entities, micro-entities which has total assets and liabilities are below 3 million. Large or publicly accountable entities and SMEs shall use the PFRS as their financial reporting framework. The large or publicly accountable entities are in the process of submitting their financial statements in order to issue any class instruments on a public market. They are also holders of secondary licenses. And SME have exceptions to apply the PFRS. Some of its exceptions are if the entity is a subsidiary in which the parent company uses PFRS as its accounting standards. 2. If the entity is a subsidiary of a foreign parent company, it must use IFRS as their accounting standards. And lastly, other qualifications must be followed according to the provision. Microentities have the option to use the income tax basis or the PFRS for SMEs as their accounting standards. Moving on to the responsibilities for financial statements. The financial statements to be filed to the Commission are one of the primary responsibilities of the entities. They are accountable to its fairness that essentially contribute to its management. The Board of Directors would check first the financial statement before giving those in the stockholders. Number 2. Shown in this page is the format of the statement of the management's responsibility for financial statements that shall be attached to the statement of financial position of the entity. This shall be properly followed by the entity. The Chairman of the Board, Chief Executive Officer, and Chief Finance Officer shall all assign the statement of management's responsibility as prescribed by this rule, unless otherwise provided in the bylaws. In case of branch offices or regional operating headquarters of foreign corporations, the SMR shall be signed by its local manager who is in charge of its operations within the Philippines. Stated also in this provision that the independent auditor must state his thoughts about the financial statements given to him. In the audit of the company's financial statements, the management shall provide the external auditor with a complete set of financial statements, all information that are relevant to the preparation and presentation of the financial statements, and any additional information that the auditor may request from management. Since auditing is a major part of business, the management shall provide unrestricted access to the documents or records needed to secure audit analysis. The independent auditor is not allowed to prepare the entity's financial statement. His only duty is to accompany an independent examination of the entity's financial statement. Lastly, the Commission has the right to examine and check if the company have followed the rule provided by them so as to determine the entity's compliance in the presentation of the SMR. We will now talk about the form, order, and terminology of the entities. Financial statements shall be filed in such form and order, and shall use such generally accepted terminology as it will indicate its significance in the presentation. All money amounts required to be shown in the financial statements may be expressed in the whole currency units. Negative amounts shall be shown in a manner which clearly distinguishes the negative attribute. The chronological arrangement of data may be with the most recent date to the right or to the left. The financial statements, other than the consolidated financial statements, shall have a stamp received by the Bureau of Internal Revenue. Last, for the Title II, the presentation for receipt of the audited financial statements. An independent auditor's report must be filed with the financial statements that firms are obligated to produce. Failure to meet any formal requirements shall result in the rejection of the financial records or the application of suitable fines. the acceptance of the financial statements accepted by the Commission without the regard to potential fines if by any material error is discovered in its content.
I will now report on the qualifications and reports of independent auditors. A. Examination of financial statements by independent auditors. All registered corporations shall have an independent auditor who are duly registered and licensed with the Board of Accountancy. An independent auditor is a certified public accountant or a chartered accountant who examines the financial records and business transactions of a company with which they are not affiliated. They are beneficial to the stakeholders involved so that they can take appropriate actions and make right decisions. B. Additional requirements for independent auditors of regulated entities. The following entities shall have the independent auditors accredited by the Commission under the appropriate category. Group A, Group B, and Group C. And the companies not included in the categories above are classified as Group D. Scope and limitations of accreditation. The general rule is that individual independent auditors and auditing firms must always be accredited by the Commission. The accredited independent auditor or auditing firm shall expire after 3 years from the date of approval of the accreditation. They are given only 30 days to apply for renewal before its expiration. Independent auditors with Group A accreditation shall be considered as a general accreditation, and they can audit companies under Groups B, C, and D, while Group B accreditation can audit companies under Group C and D. Accordingly, Group C are allowed to audit Group D companies. General accreditation requirements for individual independent auditors and auditing firm. The general rule is that the individual independent auditor or auditing firm or both shall be accredited with the BOA. For the accreditation of individual independent auditors, at the time of the application, the applicant shall have at least 5 years of experience in external audit. It is a basic requirement that the applicant shall have a sufficient knowledge of the companies applying for accreditation. He shall have a total of 60 units of trainings, seminars on the following topics. The number was actually increased from 30 units before the amendment. The said training shall have been approved by the Professional Regulation Commission, and for the renewal applications, the required CPE units shall be 90 units for the last 3 years. At the time of the application, the applicant shall have the following track record or experience. Accreditation requirements for auditing firms. At the time of the application, it shall have at least one signing independent auditor who is accredited under the same category as the firm is applying for. Each applicant for accreditation shall submit a certification on the number and qualifications of the firm's personnel or staff. Application forms or renewal forms must be notarized, and these are the prescribed forms of the Commission. Mutual Recognition Policy. The Mutual Recognition Policy is an agreement of rules and standards between the financial regulators and applicants. The Mutual Recognition Policy covering the auditors of Group C companies is subject to BSP restriction, and only one independent auditor or auditing firm is allowed to audit their financial statements. Operational requirements. An accredited auditing firm or independent auditor shall not engage in any of the following non-audit services. The independent auditor or firm shall also comply with the following documentary requirements like the company's audit reports and working papers and such, and shall operate or practice the rules and regulations set by the Commission. Moreover, the written procedure for quality assurance and monitoring of professional ethics and independence from clients shall be submitted in the application for accreditation. Any change or amendment shall notice the Commission not less than 10 business days before it takes effect. If the Commission does not comment or object to the changes or amendment within 90 days from the date of submission, the change or amendment shall be automatically be approved by inaction. Reportorial requirements. A regulated entity shall report to the Commission the following below within 5 business days from the date the report is submitted by the independent auditor. For companies under Group A, the report shall be in SEC Form 17C, For companies under Groups B and C, the report shall be in the form of a letter signed by the chairman of the board or chairman of the audit committee. For companies under Group D, the report shall be submitted to the concerned regulatory agency. If the regulated entity or company has failed to submit the report to the Commission within 5 days, the independent auditor can submit his report instead using the prescribed form. Contract between the company and independent auditor shall state that the disclosure of information by the independent auditor to the Commission is not a breach of confidentiality and shall not be a ground for civil, criminal, or disciplinary action against the independent auditor because they're just doing their job and that is the nature of their job as an auditor. Rotation of external auditors. The independent auditors, or in the case of an audit firm, the signing partner of the regulated entities shall change every 5 years of engagement. However, a re-engagement is allowed after 2 years of disengagement. C. Independence of auditors. The independence in this context is characterized by integrity and credibility. Independence is a part of the foundation of the auditing profession. An independent, reliable, and ethically sound audit gives a company credibility and allows the public to trust in the accuracy of the results. D. Engagement of independent auditors. Prior to engagement, the company shall require the independent auditor to present a copy of his or her professional license from the PRC and the certificate of accreditation issued to him or her by the Board of Accountancy. It is the company's responsibility to confirm its authenticity. It is also the company's responsibility to verify the personal identity and professional qualification of the independent auditor they are engaged with. E. Audited reports of independent auditors. The auditor's report shall contain the following. The auditor's report shall state whether the examination was made in accordance with Philippine standards on auditing. The standard deals with the auditor's responsibility to form an opinion on the financial statements. It establishes the independent auditor's overall responsibilities when conducting an audit of financial statements. In case the company has incurred a capital deficiency or any other issues which threatens its going concern status, the external auditor shall indicate in the report an emphasis paragraph that the company has incurred a capital deficiency or reasons that threatens its going concern status. It must also include a concrete plan of the company to address the issue accompanied with the statement of the auditor to verify the validity of the aforementioned plan. An emphasis of matter paragraph is in the report when the auditor believes that there is a need to draw the user's attention to significant uncertainties surrounding accounting estimates. If the company is unable to present a concrete plan or action or fails to address the issue, the auditor shall conclude that the company is no longer a going concern and shall start liquidating. You may notice that the reasons stated in the current slide are scenarios of a going concern company despite incurring capital deficiency. Other than that, there are other cases which the Commission may consider as a valid ground for considering the company as a going concern. If the company still has resources to continue to operate indefinitely, then it is a going concern company. F. Supplemental written statement of auditor. For stock corporations filing under Part 1 of this rule, which are the stock corporations with paid-up capital of at least 50,000, their independent auditors shall issue a supplemental written statement as prescribed under Annex 68B of this rule. Such statement must be accompanied by income tax return which is required to be submitted with the VIR. To support the statement above, the auditor may apply audit procedures he deems necessary. This is the end of our report. Thank you so much for listening.